almost sent this country into chaos. And therefore, as a ceasefire, they entered into this handshake that transmuted into a BBI that is seeks now to be entrenched into the constitution. And there's nothing so difficult about this. But this hide and seek that, now this is a popular initiative. And this is why we say that the powerful judicial eyes are able to penetrate and see even what is behind the curtain. And according to Justice Kairu, the President, the Right Honorable, were very integral in this process. It was a continuum, and he therefore finds that this cannot fly as a popular initiative. And we will wait to see whether other judges agree with him, or they will go the Sichale way, saying even if the president were involved, he also has a right as a citizen to be part of a popular initiative of this magnitude.
And that's a matter to adjudicate. Somehow Judge Fatuma Sichale did not address herself to this matter, but I had Judge Francis Tuyoit and Judge Gatembu address this matter specifically. Whether the president can be a private citizen. Because I had Judge Francis Tuyoit say, then probably if a president were to become a private citizen, there must be evidence then that he handed over that power to somebody else to retreat to being, a private citizen. And Judge Gatembu says categorically that the president cannot be considered then to have rights of a private citizen once he assumes that position. Judge Fatuma Sichale did not address herself to that matter of whether the president really can be a private citizen and initiate.
No, in fact, she did. She did, and gave a very elaborate comparison, saying that just like judges are judges 24/7, the president is similarly a president 24/7. And she found that therefore the president cannot be a Wanjiku and that cannot be part of a popular initiative. The only distinction that Fatuma Sichale brought in is that the president was actually not a promoter. The promoters were Dennis and UNET. The president was only an initiator. And according to her, there is no word like initiator in the law, and therefore she was not invited to find whether an initiator is illegally an initiator as a president or something like that.
Let's head back there to the Court of Appeal. I see the judges are back from their lunch break, and one judge now, another judge is going to give us his or her ruling. Let's hear from the presiding judge who is next. So we're taking you back to the Court of Appeal in Nairobi.
Honorable Mr. Justice Kiage will do his part.
Thank you very much, my Lord President. I have had the advantage of reading in draft the judgment of my learned brother, the Honorable Musinga, President of the Court, for which I am grateful. My Lord President has undertaken a thorough account of the pleadings and the procedural history of the petitions that were before the High Court, as well as of the consolidated appeals, together with the submissions made by the parties. I will thus not rehash much of what he has so helpfully delved into, and will only refer to some of the arguments made before us where necessary for contextual or illustrative purposes only. The themes I consider it necessary to pronounce and give my particular opinion on, in various degrees of depth and breadth, are the following: basic structure doctrine, popular initiative, jurisdictional objections, legality of BBI process, public participation, presidential immunity, legal regulatory framework for constitutional amendment by popular initiative, IEBC quorum, voter registration, format of the referendum question, constituency apportionment and delimitation, and then a comment or two on the cross appeals and on costs. Now, on the basic structure doctrine, of all the holdings of the High Court, none have come under furious and sustained attack by the appellants, aggrieved thereby, as those relating to the basic structure doctrine. Hours of argument were added to the thousands of pages of scholarly and judicial authority marshaled by opposing parties in an attempt to cast as blatant and mitigated error, or for their defenders, pure genius, the first of the learned judges' dispositive pronouncements on the doctrine. Supplementing their written submissions with eloquent and passionate addresses, the aggrieved appellants were categorical that the triple declaration amounted to a rewriting of our Constitution and was wholly antithetical to settled jurisprudence, both local and regional, which to their mind wholly repudiates and rejects the applicability of this strange doctrine from foreign jurisdictions far removed from our particular circumstances. In his opening address, the learned Solicitor General, Mr. Kennedy Ogeto, took the view that the Constitution has no place for the doctrine and all its provisions are amendable in accordance with clearly set out procedures for various aspects of it. The Constitution has no eternity clauses, and Kenyans consciously avoided the basic structure by making no mention of it. They struck a proper balance between hyperamendability and rigidity by including Chapter 16, which entrenched provisions with special amendment procedures. That theme was taken up by Mr. Oraro, learned senior counsel, who posited that unamendable or eternity clauses cannot be recognized unless they are stated expressly in the Constitution. When pressed to point out where the doctrine was rejected, where exactly it was rejected in the report by the committee of experts, he responded, apparently without irony, that entrenchment was implicitly rejected. Answering another question about Colombia, he said that Colombian case was an outlier and it is a divided country and we should not follow its example by acknowledging an implicit existence of a basic structure and an amendability in our own Constitution. He next made the submission that the case at bar was the first time the basic structure doctrine was applied in our jurisdiction. It had been adopted by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere and it is inconceivable that we can introduce it in Kenya. Mr. Oraro was emphatic that our Constitution provides for its alteration and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, learned counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yashpal Ghai and Jill Cottrell, Alicia Vernon, and James Gadhi, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution lest the spirit of the Constitution should create a legal theology. Dr. Otiende Amolo, senior counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned senior counsel asserted that even then the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned senior counsel Professor Gatembu still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists and brought by people who have standing. To entertain such grievances and make such orders at large leads to an erosion of the dignity and sanctity of the court. And then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyon, the learned counsel for the National Assembly, also urged rejection of the doctrine, but in the present case he considered, as he had to, that 74 amendments proposed in the BBI bill were numerous. He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel, Mr. Job Wambulwa, was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiku's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga, Land Council Mr. Ndegwa Njiru was equally opposed to the doctrine, and returning, he made reference to the Kivuitu, Priscilla Ndululu Kivuitu and another versus the Attorney General, and he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subject to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as learned counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the BBI proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit, and that changes to that core structure can only be effected through the exercise of constituent power with four features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, counsel made reference to John Locke's two treatises of government and Baron de Montesquieu's The Spirit of the Laws to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which, though not spelled out in the constitutional text, are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the Independence Constitution. He pointed out that Justice Ringera had acknowledged that, but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate, successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Roselyne, counsel warned of the dangers of populist constitutionalism characterized by constitutional capture. He also referred to Dr. Mutaha Kangu's Constitutional Law of Kenya on Devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued in favor of the doctrine, adding that courts bear more than obligation to defend the Constitution, as they are invested with the authority to defend it. He made a distinction between amendment and repeal by making reference to Black's Law Dictionary. So stating, he posited that the BBI initiative and Constitution Amendment Bill was an attempt to repeal the 2010 Constitution by implication. This is impermissible because the said Constitution is for eternity, which he explained to mean, quote, for as long as we have it. Next came Professor Kithure Kindiki Learned Counsel, who posited that there is a hierarchy of constitutional norms. And to demonstrate the basic structure, he posed the question whether one can amend the constitution to change Kenya from a multi-party democracy into a constitutional monarchy, or alter its territory by having a part of it donated to another state, as had happened elsewhere in history. To him, such fundamental changes require a direct involvement of the people. He went on to say that the judges did not say that the basic structure cannot be altered, as the complaining appellant seemed to project, but rather that such changes must be subject to a deeper process involving the sovereignty of the people. He went on, indeed, appealing to us to dismiss the appeals with costs. He turned all spiritual, submitting that the BBI process was a botched attempt to overthrow the people and the Constitution, but, quote, by the mercy of Almighty God, the High Court intervened and declared it a nullity. Next came Dr. Mudhomi Thiakolu, who invited us to consider a quartet of questions. What kind of precedent do we want to create? What incentives for constitutional compliance will we put in place? How will future presidents treat the Constitution should we lend to this, according to him, illegality, judicial imprimatur? And how will politicians behave in the future? Resorting to Greek mythology, Council implored us to recall the Hydra of Lerna, that multi-headed sea monster, which he likened to the impunity that has stalked this land, and urged the judiciary to be as steady as a sword as was the hero Heracles, and so slay it by upholding the judgment of the High Court. Learned Senior Counsel Dr. Kaminwa was categorical that the 2010 Constitution came about in answer to our rotten past and in response to global jurisprudence. Quoting from various books, he said that the 2010 Constitution was Kenya's way to sending a never again message to all that had gone wrong with us before. He declared that the Constitution is unamendable by the methods proposed in the BBI initiative and bill. The basic structure is not confined to India, but has spread worldwide. He was categorical that the problem in this country is not with the Constitution, but with ourselves, and especially with the politicians, quote, most of whom are mere job seekers who stand for absolutely nothing, end of quote. He urged us to throw out this appeal as unmeritorious. Equally scathing was Miss Martha Karua Lana Senior Counsel, who appeared for the professors of law who had been admitted as amici curiae before the High Court, positing that constitutions exist to limit the excess of authority. He lamented that in Kenya, the executive, state entities, and state officers ignore the fact. Stating that under Article 165, the courts can make determinations whether anything done is constitutional, he pleaded with us to hold that the Constitution is yet to be fully implemented as the final word on its interpretation. She asked us to mark the beacons for excesses of power by the executive and to, quote, uphold and protect the basic structure which is part of the DNA of the Constitution, end of quote. She was joined by Ms. Nyanguto, Land Counsel, who argued that the basic structure is inherent in the Constitution and urged us to uphold it and thus protect the Constitution from the BBI bill, which, quote, portends the death of the 2010 Constitution by 1,000 deadly cuts, end of quote. Coming next, Learned Counsel Mr. Zebedeo Ongoya argued that the judges did not merely import the doctrine from India, from Indian case law, but rather found it in the history, text, and structure of the Constitution. In doing so, they developed a rich indigenous jurisprudence in a manner that was praiseworthy and not objectionable to deserve the attacks directed at them. He made reference to the decision of Lenaola J, which has been referred to in the Commission for the Implementation of the Constitution versus National Assembly. He went on to say that the learned judges were correct to delineate three types of sovereign power, namely primary constituent power, secondary constituent power, and constituted power germane to a determination of the questions at bar. This same theme was echoed by Learned Counsel Mr. Ivan Zogada, who submitted that when the judges pronounced themselves on the basic structure doctrine, they were declaring a legitimate reality and were not merely engaging in lofty theory. Land Counsel Mr. Ochel Dudley distilled three strange positions, according to him, that this court would have to simultaneously adopt in order for it to overturn the learned judge's findings on basic structure. Those three are: one, we would have to adopt textualism; we would have to elevate the political elite above the people; and finally, we would have to upset a settled theory of constitutional change. Referring to the case of Kesavananda, he indicated that our position is no less perilous than that faced the Indian courts, because we have 74 missiles that are trained at our constitution. To him, changing the constitution is not a normal state function, but an extraordinary authority. He pointed out that the power to amend is not authority to annihilate the constitution, which he warned could easily be abrogated by gradual amendments. He referred to the writings of Hans Kelsen to assert that the constitution is the Grun norm. It has to be accorded a more stable character. Thus, it is not enough for those intent on altering the constitution to just marshal the numbers, recalling that such formally compliant machinations have happened before. Land Counsel Mr. Madenge took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine, because the Constitution has a core content and contains fundamental prior principles that are immutable in character. Making reply to all that, Mr. Nyamodi contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he conceded that Professor Roselyne is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya. And he seemed to suggest that it would be archaic and anachronistic to insist on a phenomenon from classical Greece where constituent power was exercised directly. Professor Muigai, Senior Counsel, in reply, labeled this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments, and specifically the case law and academic writings presented to support the rival positions, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties left me wondering whether we had facts and alternative facts. Well, I will refrain from drawing any inference that any of the learned counsel before us were out to mislead the court, at least at this point, and give it the most charitable interpretation that texts sometimes speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and suppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mora, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for a more equitable share of resources, and they ensured that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting, the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to drive formalism in construction and obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that fealty to the constitutional text itself throws open the pathways of interpretation to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It will be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights, and to be both faithful and fearless in the cause, is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. This is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I've mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further exposition. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance, to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that